Your Honor. Go right ahead, sir.
May it please the court, my name is Donald Day and I represent the appellant, Mr. Bernard Jacobs. This case stems from an arrest that took place in November of 2015, and the arrest occurred as a result of a complaint to the Naples Collier County Sheriff's Office regarding pornographic material that may be located on a computer at a private residence.
I have a question for you.
Yes, sir.
The testimony from the officer indicated that the defendant's wife conveyed to him that she primarily used one of the two computers.
That's correct.
And that computer was the one that, and does that not necessarily imply that she also used the other computer, which was the defendant's computer?
Well, the word primary could imply that, except for that when you take into context the other statements that are made, right before she makes that statement, she says to the officer, here's the computer room. There are two computers in this room. The one on the left is the one I primarily use, and she gave a color. Hers had a special color.
But doesn't the word primarily necessarily indicate that she also uses the other computer?
It could, but that evidence would be trumped by the fact that law enforcement also knew that that computer was password protected. So the only way that if you're going to infer that I primarily use mine, suggesting that you may use the other one, there would have to be some evidence that you have the ability to use the other one. And the evidence in this case is uncontradicted that the computer that the husband used, a different color computer, was password protected and could not be accessed unless you had that password code. So there was a rebuttable. Yes, sir.
You said it could not be accessed unless you had that code.
That's right.
Well, I recall the testimony just being that it was password protected. I can infer from that it could not be accessed except by the code.
Well, the issue that comes there, it would be the government's burden to prove in that case through substantial competent evidence. And as the Buckner case says, that the test is that under the surrounding circumstances, would it be reasonable for the officer to infer that the person who's giving the third-party consent had authority over the item in which they are searching? We know that in this case, she had already indicated there were two separate computers, different colors. She did use the word primarily. However, she also acknowledged that the other computer that Mr. Jacobs had, his color, was password protected.
The defendant's wife?
I'm sorry, the officer. The officer and the defendant. The defendant testified, and the officer also acknowledged on cross-examination in the hearing, isn't it true that you discovered that the computer was password protected? They ultimately had to bring in a forensic engineer with the sheriff's office to use whatever subversive techniques they used to access.
Is that in the record that there was
yes, sir.
a method of access to the computer?
Yes, sir. In the record is the testimony that the forensic team accessed the computer.
What was the method that they used to?
That is not in the record.
Right.
There were no questions asked by the government at all regarding how it was accessed, what were these methods to overcome the password. Obviously,
so it sounds like we have testimony that there was password protected.
Yes, sir.
And we have testimony that from the officer that the defendant's wife said she primarily used one of the two computers.
Oh.
We don't have evidence of how they gained access to the computer.
We do not.
We don't know whether the officer could have obtained the password from the wife, for instance.
And that's true, but remember whose burden it is. If the state is going to show an exception to the Fourth Amendment, they're going to have to show through competent substantial evidence that the wife, in fact, one, either had actual authority or apparent authority. And as the Buckner case and the Trulick case cited in our briefs both provide, it is from the circumstances that you reach that inference. In the Buckner case, for example, the way that they were able to reach the inference of apparent authority is that one, the wife used the computer to play games on. That two, that the computer was on when the police arrived to search. The defendant wasn't present, but the computer was on, suggesting circumstantially the wife must have just been using the computer. That three, that there was fraud from the computer that was in the wife's name. They discovered fraudulent accounts that were in the wife's name. And that four, the wife actually had rental authority over the computer to return it back to the rental shop. And then lastly, most importantly, is prior to the search in that case, law enforcement did not know that the computer was password protected. So it was reasonable inference based on all those circumstances for law enforcement to conclude playing the games, having access, having the ability to return, not knowing it's password protected, it would be reasonable to infer that the wife had the authority to consent. Contrary, in our case, we know there's two separate computers. The wife described, I concede she used the word primary. I'm not sure she meant it in the context in which we may know the ordinary definition of primary, because she points out there's two separate computers. The one on the left is her color, the one on the right is the husband's color. There was no indication she'd ever been on the computer. There was no indication she had access to it. There's no indication she picked it up or purchased it or returned it. All of the types of factors you see in Buckner were not present in our case. So all it was just an inference that because she used the word primary, that somehow suggested she'd been on the husband's computer, she had access to the password. Well, those are presumptions that we cannot make. That conclusion, as the court asked me, could only be reached if there's competent, substantial evidence to support that conclusion. And not only was there not competent, substantial evidence, there was no evidence to support a conclusion that the wife had access to the husband's computer in any way.
The competent, substantial evidence does not have to prove that she did have the password or prove that she did actually access that computer. It need only support that the officer had an objectively reasonable belief.
I'm sorry,
that she did have the access under the case law that gives rise to her authority,
yes, sir,
her apparent authority to consent.
I would partially agree with that statement, except that I would disagree in the context of actual authority, because in a third-party consent, there's two ways to consent. One, the third party has actual authority, and two, they have apparent authority. Under the test for actual authority, there must be competent, substantial evidence to show that the third party had actual access to the computer, used it and had access. I don't think that's an issue in this case, although the trial court concluded in the opinion that she found that the third party wife had actual and apparent. I don't think there's any evidence that suggests she was ever on the computer, and that'd be required for actual. For apparent, you are correct, Your Honor, you don't need direct evidence. You can conclude that from the circumstantial surrounding facts. And that's why, again, I would suggest that there are absolutely no facts other than her statement. This is the one I primarily use. Can you conclude from that? Therefore, she also uses the husband's. She also knew the password. She went on it on occasions. I don't think you can make that inference. You'd need evidence to support that conclusion. That's not an inference that can be made. Otherwise, we would be assuming all the time, if you just walked in on a third-party consent case and someone claimed, yeah, I have the ability to use that, that would be enough, and that would not be enough. You'd need some other additional factors.
So wait a minute. So you're saying if she had said, oh, I have the ability to use that, that would not be enough for apparent authority?
It would be. That's what I'm saying.
Oh, okay.
If then she says, I go on the computer, I play games on the computer, like the Buckner case. I'm on the computer, I play games, I access it, I have the passcode. All of those types of things obviously could not only show actual but also apparent authority. But you don't have any of those facts in the case before us. There's no circumstances at all to suggest that she had the apparent authority other than her statement, I primarily use that computer. There are a few cases that we cited in our briefs. I think in the Buckner case, there is a case from the Fourth Circuit, also the Truelock case, that I think provides a great deal of assistance to us. And in the Truelock case, it was a situation where the FBI was being sued civilly for unlawfully accessing a computer. And in the Fourth Circuit concluded in that case that a password-protected computer that a co-resident did not necessarily use or know the password lacked the common authority to consent. And Your Honor, I think that may assist a little bit in some of the questions you asked me in that Truelock case, because what the Fourth Circuit concluded is that there's a special, I don't want to use the word rule, but a special consideration you would give in answering this question if there is a computer that's password protected. The Fourth Circuit described that as a lockbox, no different than a keyed lockbox. That if I own a lockbox and I have the only key and someone takes my key, just because they have my key, it doesn't mean they have the ability to go in my lockbox. The Fourth Circuit drew an analogy that a computer, a password-protected computer is very analogous to that lockbox situation, and concluded that in that password-protected computer, you cannot have common authority. So we know in our case, there is a password-protected computer in the room where there's two completely separate computers. There's no evidence in the record that the wife ever accessed it, went on it, or had that access code. So the True Luck case, along with the conclusions reached in the Buckner case, we believe support our position. Now, in the trial court's denial of the motion, there were several things that she indicated formed the basis of her decision. And I think the one that speaks volumes to our position and why we believe the court erred is at the very end of her opinion, the trial court seemed to find that the statement from the third party, the appellant's wife, where she said to the officers, "Take what you need," that was the word she used to the officers, "take what you need." The trial court concluded from that, right after she was rendering her decision, the trial court said that statement gave officers valid consent to seize anything she had common authority over. And with all due respect to the trial court, I think that is an erroneous statement of the law. Simply because a third party in a residence makes a statement to the police, "Take anything that you want," doesn't necessarily automatically confer common authority over everything within the residence. There are still things within a residence that there's a reasonable expectation of privacy in, even if one is married. We cite in our brief examples of where there may be confidential computers or cell phones or records within a residence that a husband or wife or child, adult child let's say, has a reasonable expectation of privacy in those records and documents, and that husband or wife even goes to the extent of locking it in a lockbox or protecting it in a password-protected computer, that those are affirmative steps to continue to affirmatively show their reasonable expectation of privacy, and that reasonable expectation of privacy under the Fourth Amendment and the Florida Constitution is not circumvented merely because a resident says to the police, "You can search anything you want to." So I think, yes,
I want to segue to something else because in the interest of time, a lot of the statements of the defendant's wife, I hesitate before saying they were taken out of context, but I think there's another context in which they could be viewed other than the one you presented them in, in your briefs, and that is that she had some suspicion that there might have been something illicit on the defendant's computer, or at least at bare minimum she knew that the police were there for that reason. And so a lot of the things that she was saying, for instance, by saying, "This is the one primarily used for my husband," or I don't really care much about computers, was exculpatory because she wanted to convey to the cops that I don't have anything to do with whatever you're looking for. Why wouldn't that actually support the inference that the officers might reasonably have taken from the word primarily, meaning, well, yes, I use both computers, but this one is primarily his, and this one is primarily mine.
So we would be limiting ourselves to the apparent authority, because clearly that wouldn't constitute actual. So under the apparent authority standard, I think the answer to that lies in, if you review the entire record, the complaint is made from another third-party family member. We don't know the nature of the specifics of that complaint. That wasn't in the record, and the officers didn't make it clear. They only said someone called. The appellant's wife, along with that other family member, were aware of this allegation prior to the police's arrival. So I don't know that you can simply conclude she knew there was pornographic material and she was covered in some way. She knew why the police were coming because she had already had a conversation with another family member. Now that's in the record. That's not really mentioned anywhere in any of our briefs, but it is in the record that third party, as a matter of fact, that third party was called at the hearing in the motion to reveal that.
And I have one more thing that's
yes,
not in the briefs.
Yes,
it may be in the record, and
sure.
I apologize ahead of time because I didn't find it in the briefs, or maybe I missed it. But if you're correct that there's neither apparent nor actual authority, why would not the inevitable discovery doctrine bring this outside the ambit of an illegal search?
Well, there was several problems with their inevitable discovery doctrine. First of all, the police did not have a sufficient basis to seek a warrant because this is in the record, I'm fairly certain, Your Honor, because she was called as a witness, but there weren't any real details about where the computer was, what the pornography was, when it was discovered. So this third-party complainant would provide an insufficient basis to obtain a warrant. And I think there was some discussion in the record too, and I could be wrong again, but I'm fairly certain there was some cross-examination on this. That's why law enforcement chose not to go get a warrant. Remember, they get a complaint, but they don't go get a warrant for the residents. They chose to do a knock and talk. And the knock and talk was because I think even law enforcement knew that there was insufficient evidence to obtain a warrant. So therefore, when it comes to inevitable discovery...
Well, if we use that, I mean, I'm not dismissing that out of
Yes,
hand,
sir.
but if we use that as evidence that there wasn't enough probable cause to get a warrant in every inevitable discovery case, then there would be no inevitable discovery doctrine if you said, well, they didn't have a warrant yet. But, and that kind of also,
Yes, sir.
I guess, and again, in the interest of time, I want to say, well, the testimony of the officer was that they were in the process of obtaining a warrant. And that the testimony supports that process was concurrent with the knock and talk.
But respectfully, Judge, I don't think that's entirely accurate. I think what they were saying is once they got inside, they brought their forensic member in. The forensic member went into the computer in the house and saw information, and they went and got a warrant. They were trying to get a warrant for the rest of the computer. I mean, it was kind of done backwards, and that wasn't an issue challenged in this case. But we had some discussions on the record about that, I believe, with the trial court, that they had already looked at information in the computer, and then we're going to go get a warrant. And that posed a whole nother set of problems that, you know, if you unlawfully obtain the information, can you use that unlawfully obtained information in
That
warrant?
may be a better question
Yes,
for the state, but
Yeah.
The testimony of the officer, for the sake of discussion, I'll say that I believe there's a fair reading of it to suggest that the warrant process was underway at the time that they arrived at the house for the search in question. And I think you pointed out something that's interesting
Yes,
in
sir.
regard to that analysis, which is that the affidavit included evidence from I forget what's called the preview.
Yes, sir.
Is that right?
That's right.
Are those two things irreconcilable? That they could have been in the process of putting together an affidavit and getting a warrant
Yeah.
at the time when they actually did the preview of the computer and later used. Are those two things incompatible? That the warrant process could have been underway, and also that some of what they found in the preview made its way into the affidavit ultimately?
Well, we may have to go outside of the record to answer that.
Well, we shouldn't do
And
that.
I'm not suggesting I'm going to do that. I'm just saying, though, that the answer lies outside of the record. What we have in the record is that they went there to do the knock and talk. They believe they uncovered enough evidence to get a search warrant. The problem that posed is some of the evidence they uncovered was by a search of the interior of the computer. So we never got to that issue because the original issue for us was if they unlawfully searched the computer, then necessarily anything they obtained from the search warrant would also fall later. So this issue would have kind of addressed both of those things.
Excuse me, Mr. Day,
Yes.
you're at about 18 minutes of your time, so if you want to save a couple of minutes.
If I could reserve 2 minutes, yes, sir. Thank you.
Thank you, sir.
May it please the court, counsel, my name is Blaine Goff. I represent the appellee, the state of Florida. The trial court in this case applied the correct standard of law, that there was a consent to search, and that it was supported by competent substantial evidence. So basically what occurred in the motion to suppress, the evidence presented was that the police were notified by the appellant's wife, or the appellant's daughter, that there was child pornography located within the house, and they went to the house, and after talking with Ms. Jacobs, they learned that the house was co-owned by both Ms. Jacobs and Mr. Jacobs, that the computers were in a room that was commonly used by both of them in a common area. Mr. Jacobs was not present. He was in the hospital at the time, and she led them to the room with the computers in them, and she told them that she had purchased the computers with Mr. Jacobs, had completely set up this house and the residence and where the computers were, because Mr. Jacobs had never lived in this house. So they were operating with that knowledge prior to searching this computer. She gives them verbal consent and written consent to search the computer. And at that time, at the very least, this is objective and reasonable that she had the apparent authority to search the computers. I believe she also stated that she hooked up the internet and made sure that the internet was hooked up, that the computer that she primarily used was not even hooked up at that point. And she also stated that she uses the computer to check her email. So all of these...
But she didn't say that she didn't say any of that was specific to the husband's computer.
Right, and what the police officers using this information to act on an objectionable reasonable belief that she had the authority to consent to this search. I think there's an argument also that she had actual possession, actual authority to search this computer as well, but at the very least it's apparent authority that they were operating on this belief. So even the Buckner case, they find apparent authority, and there were some similarities in that regard, in that the password-protected computer, I believe in that one the files were protected, not the actual computer. And in that case, she also stated that she didn't use the computer that much either, but the court found that there was apparent authority in that case and that the search was reasonable and the motion to suppress was affirmed.
Can I ask you divert our attention to
Sure.
the daughter?
Yes.
I think what she did was important for a couple different reasons. I explained it to counsel for the defense. One is that that is part of the circumstances that suggest that the wife had some indication of why they were there, and also had from her testimony you can infer that there were things in the past that had happened, and she had a suspicion of why they were there, if not an outright knowledge of why they were there, which plays into what her use of the term primary. And the second thing, though, is the inevitable discovery doctrine, because you have two problems, and I wanted to ask you about that. One is whether what they had before they knocked on his front door would have been sufficient to support probable cause, whether under the the Florida Supreme Court Rodriguez case, which requires that the warrant process be underway, whether you need to, I think you need to have the requisite facts to say that probable cause would support a warrant, but also can you have inevitable discovery is established when the ultimate affidavit included items from the search that you're trying to make an exception to.
Well, I don't think, like the court previously said, I don't know if they're mutually exclusive. The record's not clear on exactly what they had, if they had enough, based on what the daughter told them. I think they might have, they could have, but the record's not clear in that. And once they obtain or go in and get that consent to search, the warrant, she could have been making those statements just like she could have had knowledge, but it's really what the police had the objective reasonable belief on if she had the consent, not so much what she knew, but she could be clarifying that she's not the one that accesses the illegal material, but that she could still use the computer in that case. So I believe that the record's not clear on if the warrant was actually in the process of happening, but they could have been doing that. It's the trial court kind of is the judgment of the facts in that case, and that's kind of what the trial court was looking at, more on the apparent authority or the actual authority on that. So I really can't answer the question on whether or not they had the working on the warrant or not at that point, because the record's not clear as to that.
Are you taking a position on whether if there was no actual apparent authority,
I believe it was
discovery
it would have been inevitable discovery in that case, but because the daughter went to them, she found, ledgers of illegal material, she found maps to parks and schools and pools and stuff like that, and she stated that there were zip drives and everything like that, that this was at the motion to suppress hearing that she testified to this, and you could assume that they were given that information and that they were working on possibly a warrant. So if this court does not find actual or apparent authority, we would certainly argue that it was an inevitable discovery because they had that information, and probably could have secured a warrant if they had that information if the court doesn't find that there's actual or apparent authority. But we're arguing that there's actual and apparent authority. At the very least, there's apparent authority in this case.
But the officer, when questioned about the warrant process, said that they were in the process of obtaining a warrant or already had one at the time of the knock and talk. Am I correct? Well, I know I'm correct because I read it.
Okay.
Okay.
So I know after they found it, that's when they interviewed Miss Jacobs, and 2 hours after they found the child porn, that she stated that the one on the left is primarily hers and the one on the right is primarily his. And so this was after the discovery of the child porn and the discovery and when they were actually seeking a warrant at this point. So I know at that point this information about which primarily used computer was 2 hours after they actually were given the consent to search and found child pornography and were working on a warrant, even more so if they were already working on it. So I'll defer to the court if you read that they were working on a warrant beforehand. I personally don't remember that in the record. So again, I believe that a lot of these questions are questions of fact, not necessarily questions of law, and the trial court's in the best position to have heard the testimony of all the witnesses in this case. So the trial court certainly did not abuse its discretion in applying the facts to the law in this case, which is that, Ms. Jacobs...
Which are the questions of fact that we can't disturb?
Well, the questions of fact are the testimony that they co-own the house, that they... what exactly the police officers heard and whether or not that was credible to find apparent authority, or that the police were acting objective and reasonably when they believed that she
Isn't that a legal question? Whether the objective reasonable test applied to the facts, isn't that a legal question reviewed de novo?
Correct. But I think some of the issues were at what point did the wife give this authority, and what were the, basically at what time, did she say the computer on the left and the computer on the right was primarily used, and these color issues. Really, some of these issues are really just an abuse of discretion standard, but of course, you can take everything and apply that de novo on whether or not the police acted objective and reasonably when they believed that she had either apparent authority or actual authority to search. But again, she purchased the computer. She said she used the email. She said she set up the internet. She set up the computer in the house. She owned the house. It was a jointly owned room. All of this suggests either she had actual or apparent authority. And if the court has no further questions, we'd ask that you affirm his conviction and sentence. Thank you.
Thank you, Mr. Bell. Mr. Day?
I want to respond specifically, Your Honor, to a couple of questions that you had, because I did find some transcript sections that I think may assist us. Page 73 of the transcript of the hearing, I remember specifically, and I wanted to go back and look at it, that I asked the officer about the search warrant issue, because it came up a number of times pre-hearing. And specifically in that section, the officer acknowledged that in his affidavit for search, he put in the contents in that affidavit of things that they found after they searched the computer. And there was some other discussions about that, but they did affirm on the record that the affidavit for search contained what we believe was unlawfully obtained information after the search of the interior of the computer. So they have not even sought to get that warrant prior to them actually looking in the computer and seeing what they believed was pornographic information.
Real quick, I only have limited time, but the question is whether under the Rodriguez case, that whether, what being in the process of obtaining a warrant means.
I understand. I would respectfully suggest there's no evidence to show that they were in the process of obtaining a warrant. There's actually evidence to the contrary to show they didn't even attempt to obtain that warrant until they had already searched the computer.
Go on.
On the second issue, Your Honor, you had asked me about the words primarily used. That came up in the hearing because it was unclear whether the officer was summarizing the statements by the wife or those were her actual statements. Page 81 of the transcript of the proceedings, I specifically asked the officer, are you sure Mrs. Jacob used the words primary use computer? The officer's answer back on that page was that he was not sure what her exact words were. He was paraphrasing. So you can't even say that she used the word primary. That was the officer's paraphrasing of her statement. So I wanted to point that out to the court in specific response to the question you had about that. All right, thank you.
Thank you.
Thank you.
Thank you both.